Deputy Speaker, sir, the bill which has come, the Benami Transactions Provisions Amendment Bill, sir, by clause 3, you want to introduce this act may be called the Prohibitions of Benami Property Transactions Act 1988. This is how you want to do it. Why you are not bringing new bill itself? Why in an amendment, if the bill's title goes like the Benami Property Transactions Act 1988, why you are amending a bill of the Benami Transactions Provisions Amendment Bill, which is further to amend Benami Transactions Prohibition Act 1988. The original act is 1988, which is Benami Transactions Provisions Act 1988. And you are now you want to do the Benami Property Transactions Act 1988. Quite different. You are trying to bring new things into the old act. If that's so, why you are not replacing a completely new act itself? In fact, sir, through you, I draw the attention of the Honorable Finance Minister, and it's also a great privilege the Honorable Law Minister is also here, and it is all the time my privilege whenever both of them are here. Sir, the Standing Committee of Finance, Ministry of Finance, in their 28th report, in part 2, exactly recommended for bringing a new bill itself, new act itself. If there is a total change of characters, why? What is the requirement? What is the object? Let's see. We have heard the speech of the Honorable Finance Minister in 2015 regarding stopping of black money, bringing black money also, Benami. Main thrust of the thing is this, whether these transactions are coming from the backdoor process or through the black money. Today, if I have a white money and if I transfer a property to anyone, it's not a Benami. Benami is if a money whose source has not been disclosed and cannot be disclosed because of this is earned out of illegal activities, and out of which the property has been purchased, then it is called in different name. It's called Benami. I had a little experience about that. So I just take. In 1989, I purchased a second-hand car. I was a 7 years practice. So car was given to me. He said, yes, all right. I will give you the documents, etc. after a few days, and I believe that. 2 years I have not been given. In 1991, my car was stolen by someone. It was now the car, when it was produced before the court, competent court, naturally the owner has to be applied. He has to apply. My name has not been changed. Then I had to take the help of the police commissioner. Police commissioner went, sent the officers. Ultimately, it was found the gentleman who was keeping the car, his man was staying in a remote village of the Bihar. His domestic servant, it was there. These are the Benami property. This has to be stopped. So now I come to section, one after another. The clause 9 of the bill itself. Sir, clause 9, a person shall not be qualified for appointment as chairman or a member of the adjudication unless he has been a member of the Indian Revenue Service and held the post of Commissioner Income Tax and has been the member of the Indian Legal Service and has held the post of the Joint Secretary equivalent post. Chairperson and other members of that shall be appointed by the central government, appoint the senior most member to be the chairperson of the adjudicating authority. How can you distinguish it? Seniority can be distinguished in same cadre itself. How can you distinguish? How can you making a difference, seniority of an income tax officer and a district judge or a legal service? And this income tax tribunals matters, the constitutional bench judgment, Chennai matters, that you have know that the power, if it is not vested with the, where the judicial officer is there, is not given, and it is given to administrative officer, then ultra vires. Therefore, one has to ensure why the chairman would be, where a person coming from a judiciary, maybe district level, then why an administrative officer? And why revenue department is being included in everywhere? Income tax officer will run after the persons. In our country, they are the most failure persons. Only one person pays income tax in our country, 3%. And 3%. And those who are paying tax, income tax officer will run after them. And those who are not paying tax, they will never touch them. They will never touch them. If there is an advance tax is less, if I remain 3 months in the parliament continuously, then I get a notice. Why tax is less? Advance tax. But those who are not paying taxes at all, they have never been caught up by the income tax officers. This is the situation. Instead of revenue officers, it should be somebody else. He is not the income tax is not the main questions here. Questions of property is there. Sir, against clause 30. Clause 30, you have created an appellate authority. Appellate tribunal to hear such appeals. Sir, with great respect, where is the provision for preferring an appeal? First, there must be a provision to prefer an appeal. And if appeal is preferred within how many days? This is silent. And no. It cannot be made in rule. It has to be made in the statute itself. And in that case, sir, I will request you, if an order is passed by the adjudicating authority, then in case in the appellate tribunal, kindly consider to power to include even to pass an interlocutory order. Otherwise, everything would be frustrated. Ultimately, when the final appeal would be heard by the High Court, then everything is gone. A person also should be given justice. One can see it's a benami, one may not see it's not a benami. One may suffer from victimization also. Therefore, this power should be given. This certain protection should be given against the order itself. Clause 30, you have created the central government shall by notification establish an appellate tribunal to hear appeals. But where is the provision that there is a right of appeal against an order of the adjudicating authority? Then time limit is not there. But in case of the High Court, appeal, there is a time limit of 60 days time limit is there. Limitation of 60 days is there, clearly it has been said there. I will request that in the bill itself, give power to the appellate authority to pass any interlocutory order. Sir, the committee which has the finance committee, Ministry of Finance committee which has submitted a report, that has said they have recommended, they have highlighted a ground reality. Ground reality is in the rural areas, lands are purchased by cash. For decades together it is being done. In the rural areas itself, and in a case of the illiterate persons, keeping dalils, deeds and etc., it is really very difficult to get. So far the rural areas are concerned, poor peoples are concerned, those who have purchased the property, that property, if the dalils, wills, the documents, instruments are not theirs, then we should take care that this property should not be brought within the scope and ambit of the Act itself. Therefore, sir, I will request to you, kindly give thrust to the aspect whether the property is purchased or acquired by reason of any undisclosed money or tainted money. Apart from that, if it is not purchased from the tainted money or undisclosed money, this property should not be brought within the scope and ambit of the Act itself. I must say, sir, number of mechanisms have been created by you in this bill, but kindly give a rethink over this. I can make a request to you. You have really given a completely new thought, which I appreciate, excepting very few which I have pointed out. I appreciate the intention of the bill itself. I appreciate the mechanism which you have fixed up in this bill itself. I have no doubt about that. But since you have given a new thought over the entire things, it is better to bring a new, completely new code itself, giving details of everything. With this, sir, I am concluding.
Thank you.